Very often you hear about tort reform or about caps on damages, that either the legal fees or the amount of recovery in a personal injury case should be capped. And the insurance companies like to tell you that that is because there are too many lawsuits, frivolous lawsuits, and there are too many runaway juries that allow for millions and millions of dollars. Now, is this true? Is this the real reason? Or is there another reason hiding behind that's the true reason behind tort reform? My name is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and let's dive deeper into this idea of tort reform. One of the ways that tort reform exists is they limit the amount of recovery, either in a certain type of case, like in medical malpractice. Some states have that you can't recover more than $250,000. Another way is that in some states they have caps. So a jury can't allow for damages that the jury thinks the case is actually worth after a full trial. The jury listens to the doctors, listens to the plaintiff, the defendant, all the parties. It's a full trial, but they can't allow for full damages. And if they say, look, the damages are $2 million, some legislator, right, some senator or representative is going to say, no, in my state, the most anyone could ever give is $200,000, and it's a cap. And so the insurance companies, the idea behind it is you don't want these runaway jurors. And what they're also doing is they're limiting the attorney's fees, and they're lowering the attorney's fees. And it's all under the guise of, we don't want too many lawsuits, especially in medical malpractice. We don't want doctors being sued. And in New York, they have a rule too. In medical malpractice cases, you could only recover 10% if the amount is over 1.25 million. So for example, if I'm handling a serious medical malpractice case and the amount of settlement is $1,250,000 or more, the attorney's fees on that amount above 1.25 is only 10%, which is a pretty small attorney's fee compared to other states where they can obtain any amount, even 10 million, 20 million, and they get 40% of that as an attorney's fee. And so I was talking to one attorney earlier today, and we were thinking, like, why is this happening? Is this because they're really trying to limit these cases? And, are there too many lawsuits against doctors? And the answer is no. In reality, it's because the insurance companies, who are already billion-dollar, corporations that make a lot of money, they just want to save more money. And they think by limiting the attorney's fees that the attorneys won't pursue the cases and won't take the cases to trial and won't have the financial incentive to get full justice for injury victims. For example, I handled a brain damaged baby case for a medical malpractice, and I thought the case was worth millions and millions of dollars. And while I'm negotiating it, the insurance adjuster tells me, well, I'm going to offer you 1.25. You should take that. It doesn't really matter if I offer you more, like 2 million or 3 million. What's your incentive? You're only going to get 10%. And I said, no, it's not about me. It's about the client. The client's injury is a life-changing forever injury. That injury is worth 5 million or maybe even 10 million. I can't sell the client short for 1.25 just because of my legal fee. I'm not doing it for my legal fee. I'm doing it for the client. And this other attorney, shared the same sentiment. So that's really what's happening here. So you have to be careful with the way these insurance companies have these strong lobbyists and the way they spin everything, because a lot of the times what they're spinning is a bunch of BS. So be very careful and look at it with a fresh set of eyes and, evaluate it for yourself. So I hope this is helpful. And if you have any questions or need a consultation, just text me 347-566-9595. We are here for you. Our goal is helping serious injury victims and families get full justice.